abusia mfo ma munyina akwa wasonko eba RAZ media so abusia said the yen in the manche bia na speaker Agwambaben etna na konwa mo parliament to 4 parliamentarians and him say their seat are vacant. Adentia or see because they have decided or they have had an intention to go independent in the next general election coming. And I'm also in a Supreme Court of the land. Afenyo mark and I know the majority leader. Ede case got to one him say the speaker ne yen yemra kwanso nti omum famra ehwem na omum the right thing to do. And no when the Supreme Court let the comma Barben, the Speaker of the Parliament, say, Onyanto boasie na omunye hwehwemu na omunhu say mrana person for ni MPs no correct and I say correct. We in a speaker so no sa semna Supreme Court on the buy on tiasie. Eno ena ko fans nsema ba ene Agwambaben ene lawyers akopie Supreme Court wa Supreme Court judges a school Agwambaben say we speaker na nkyere se Ghana man eye wo de yem konkotie nsema esiye e wo Supreme Court ye ba ye be sign ato aso
sorry mapona
yempon ye nemum ye break kakra make ye study case ni down a different panel never betina say na omaka ensem foforo nemum omo page omu na atimwafo num sit on afenyo markings NPP caucus Rashe Bedufim ne speaker and sense attorney general some normal badia na ehono na ebehu say enipa numa chief justice kan ho bi no den asem no de went to see the make say ye go break and break we a second break ayako first break and away etosumi no ayako second break
amana answer na break ni beba no omoka ko si sen
Obo bi mamenda wa senior nyina ne say the first break kransa ne yebe ko no na second one we ababa mamemfa emfi ase wo so the first break I see ase ye first seminar pe na lawyer side of sorry I will no any lawyer ni edema speaker of parliament Alban Sumana Kingsford Blackburn wono ebo ni din Sarah enso na lawyer abedu enso ebo ni dia wono na ejinem edi ama plaintiff no eno echi no na attorney general and minister for justice Godfrey Yeboah Dame enyo no kwa na wa ene attorney general me nsa ni nyina asona ba abena da power ha nanso na Alfred Tua Yeboah enso na wa ha attorney general me nsa ye wo nyina e wo court ya na no na sakra na sem no ye be fi ase kwekam na attorney general sorry say owo ye friend of preliminary legal objection and then cat I find it is because na lawyer for the silence and then do what we and the answer the cafe ye say cat language because parliament and man lawyer for your side of the or say do why the cafe attended in trade in queen na ba kwa waka wasem kese pa ne say as a speaker can actually court and say chief justice in the Massimi will be as a yet kind of betina susu who crowded in Kratane by yapping and our G edituma a ex party application on the buying and what Attorney General Sanchez said speaker and Casayemo Namna lawyer for so try and say I say chief justice and the ones to Sunday decision say a be a stay of execution no making and say a be and say be a madia now or the cafe. Chief Justice any Supreme Court at the Mwafo Ninano, they say, Yebeka Somodo Mwakwadon, Amanokubi, or Pekase, a partisan, and not some of the Mwakwadon, Amanokubi. And no, and a bra, Attorney General, Godfrey, Yeboah Dame, at the Sansum way to Javian. Kind of sorry, a lawyer ni at the Speaker of Parliament, as original said. We any scandalous be as the Yebeka say, it's your court in the fan would so, and would you court, not a manasi or book court in any sense, there be, or secret, dear. A chief justice a share a course speaker of parliament in China and no king kaya speaker and so catch and say Josa and some Efabra and into send a idea say attorney general Kase will speak a book court in any tia or the court in the form there or send Ukrabia Enisa and Semini. Nano and a first break in the court and a sorry cool Omo and a speaker a chief justice or Penny Gertrude Araba Toko no HSA baby. Sans Samana, Omokeka, any in the ruling ever, the ruling or the buy and chester baby. adwuma na omo ye e Supreme Court ho no eye constitutional matter eye 1992 Ghana ya mamra no ho bra na yebo we enye NDC na enye NPP nti o se enye political matter na we eye constitutional matter. The second argument epeja wo mu ebio eye otemuafo na so enum emu baako eye Justice Eric Gawu ono na eye lawyer ni edema speaker eye lawyer side HSA papa na ote ho se Supreme Court otemuafo en kanibi o se oye former parliamentary candidate edema NPP amayuku enti panel no ote so no omompe yenyi ni enfri panel no so eno so ebra mpanifo enumi ekọ ebaye no Chief Justice HSA Supreme Court yenya temuafo bia na ebi ye PNC4 omo betena so ye adwuma na obi so NDC ni obetena so ye adwuma into we ka say it's neither here nor there say obi enkani bi yes say na o contest say NPP parliamentary candidate intinu ini ni emphasize into sansem no so ye botu afi NSA o move application na o move yen lawyer side of ejina point mako and 9 so point 1 purchase no cre sa enkrata expatia afenyo markens de buy ni nyina enya so bi anim anka ba bia so de na ni kire nyina ye high court esan said court no ya hwehwe ne such a way say o bibia wo ha obi wo amanye bi na pese okokota unim ba bia wo ko na mum untutu mampa America na sometime Supreme Court and ababejina enu achi o say article 971 G&H ya akofa mentime wase da were twen nyina aban anka no so ebekwa kowie ekowie ewo high court na high court and constitution ankasa church high court no jumedia esese omuba bedi o se ne etosubi eye ne nwanwa pa se ene speaker ono ne ruling na omaye ewo Parliament House e bedu Supreme Court say ya must stay of execution and no che say there be the speaker ye no emrand man na ho kwan pefe esan say no ye no enye constitutional issue and na no ye no so enye Supreme Court and say High Court and ma oda no o ye on the floor of Parliament eho and ye beka so di ne hene eho and no ye boys prefect and say class rep ewo it is some na wo share say enipa na ye ma so bigafon omo fo makonwa nto ye na ne akonwa ni mutu o se emre bie ni ho a etia ne speaker eye nti eye na nwanwa pa se ene Chief Justice so etena se na expert no ordina so e ka se ne speaker eye yen say ko se ye beka ansem ni na ewi na owi ye na lawyer abedu a wono gina media ma plaintiff no so e ka sai e na o che se no kre ne speaker ka ni nyina debi emra na nkyeresa nemum emra na kire se expert na afenyo market de buy eno eye no ano no sanse se nipa nan ya mrahye bedwafo se ya ma omkwan se omnkoso ntina mrahye bedwafie ma e do how beba omompehia so fon ombeye de no manyansu ombeye de no manyankane nti o se omontwen enkosi se ye beka se ni nyina awie enti number expert ni se near Supreme Court and so yeah and I'm not quite so pepe on should be ya pe and Attorney General original Attorney General so kasa yemu near what can you say or no the and from so bia Supreme Court say or de ne ruling no e buy and I say stay of execution e buy minimum in kasaya speaker and I'm the lawyer for a show at the back court no and no so say enye na all kasa na and Chief Justice catch and say on fanchire mumra essence or no and a Ghana mrano ekura na ochire Ghana ebrem eye Attorney General and all catch Ghana for nyina say or for the benefit of the data Ghana for do na ehweti 80 NG 102.9 FM tin on cheche mu or say ebra no be ye Chief Justice pepepen eno hu say enkrata ada ho a ewo kwan ya ye fa so ekokọ serve Rashe Bedwafo or say Speaker of Parliament and kasa to ne nsa frɛ no ene ne kwatena ase no hu san hyehye no ene ogitu mu se ene ekwan ben so a ye befa so ne ahyehye ne yie se de mra ne kyerɛ sɛ obi kɔ Rashe Bedwafiem anase obi pie fi Rashe Bedwafiem no ye Rashe Bedwane a yen serve no wɔ kwan so no enhyehye ben ene hyehye to o se eno na nam so ma ɔde sa asakula no ɛkɔ se ene adwada ene ye yesi wo se yen kɔ serve Rashe Bedwafo na ase se de ebi ya fa bronya ho awe enkrakase Mini obobi eho ene yedi sansem no akwakowo a obia making argument awie atemofo num no asori omo ba ene yebehu se then ye speaker kan ye na ye stay ye na obu so anase wa mu so anase enipa nan a eye article 971 G&H ya akofa da wore twe menteme ho ase bebraba no e de asem e de befiri mu aba ene the Supreme Court de ka no ene yebehu se ni nyina etu atwa anasa etuntwa obi be sign aba review anasa appeal ewo ho
Enti ama sɛ meti da ɔka ni yie dia na yɛ sɛ ne kwata yɛbɛhu asɛm no pomasi brɛ
omo bi se bibia nsesa oma sorry so omukwa kofa ruling naban ebetimi aba so ombeba no de date keka aba abeka se ebia otene ya wada efiada na momra na momaji ruling no ananse ye ma date foforo bi se momra but se ne omukasa ye no ene obi a making argument ne de meje de se omobe maye ruling na mom ebia reasons ntia omo conclude ekosi ho no omo ka se echire no ye beba aba beje no ka se court why ma supreme court why ma papa one way na so resema ba ku mienu abekwa ban na why a lawyer for nso aba begum ba betie fom ho de ma hye bedwafo a mehu om dodo na no NPP kokosi no afenyo markings wa ene owura jogati ene wa hye na lawyer tade papa eneja wa hye ne wigi eti akonyema wono no lead team na ejinam ediama plenty no enti lawyer afenyo markings ono aye lawyer ni ene ne lawyer wo jinam amano owura bedu ena jogati obi anim say first na oye railway minister ni aden ene oye lawyer ni mapa court dem court wa abobe oba bonten so a menua aposifo egu ha no meka se mehu aposifo bi wa ha democracy hub for na bra ye de wo moban na aposifo a egu ha no enya aposifo ketwa wo munyi na ehwe aboban masunjia ba me no ka se lawyer atachia eni mpanifo ni bi ena APA edi bonte afenyo marking so pie afena o sign erem wo ha mpanifo dodo na abepi
notice that indeed that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General file issues for determination in this matter, and those are issues raised in the for determination by the court. Especially, indeed, the application completely misunderstands and misconceives the Supreme Court's original decision. And I made the point that, indeed, the court would notice that Article 2, Clause 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2, Clause 1, I pray the court not to look only at the article, but to even read it with Article 3, Clause 1 of the Constitution. Article 3 of the Constitution, Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen in respect of that provision. Clearly, the meaning of Article 97, Clause 1, paragraphs J and H, as advanced by my learned friend, Counsel for the First Defendant, in which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a civil case in it, and totally his understanding, with all respect, is wrong. There cannot be a more demonstrable case for a controversy as having arisen in respect to the provision of the Constitution than the instant case. But indeed, my respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoking the decision of the Supreme Court has to be set aside. That would be the basis for lawless conduct. And this honorable court owes a duty not to encourage it. I'm fortified in this proposition by the locus classicus on the matter before an Attorney General reported in 1980 Ghanaweb report at page 637. It is where the Supreme Court stated clearly that whenever a controversy has arisen in respect of a provision of the Constitution, it is a basis for the application of the court's original decision. Respectively, the points I make today are not points being sought to be established today. They are matters that have been long established 40 years ago in this honorable court. I quote from page 650 of the provision. And indeed, it was also a controversy regarding a decision by Parliament. Parliament had actually made a decision to subject the Chief Justice of the Republic to vetting. The Chief Justice had also even acceded to that process. The Supreme Court said that, notwithstanding the Chief Justice's decision, insofar as that decision was unconstitutional, it could form the side matter of the original decision of the Supreme Court. But the court stated that there's a controversy regarding the status of the incumbent Chief Justice, the determination of which depends upon an interpretation of the Constitution. Once there's a controversy, a justiciable issue, we believe that under the wing of interpretation as contained in paragraph A of clause 1 of article 118, the court has vision to detain the issue raised by the plaintiff's right, and the plaintiff is thus properly before the court. And respectfully, the court went ahead to make the point that in a constitutional action, the community of interest is with the Constitution. There's really no such thing as a plaintiff and a defendant, and therefore the writ which mentioned some members of Parliament, there must be a demonstration of an interest in them. There's no such thing as that. Indeed, the plaintiff, with all respect, could have omitted reference to any member of Parliament and have just stated a question for determination by the court whether upon a true and proper interpretation of Article 97, Clause 1, paragraphs J and H of the Constitution, a seat of a member of Parliament becomes vacant upon the occurrence of A and B. And that is it. And the court would have been seized with their decision. Maybe the first defendant makes reference to an alleged denial of the right to a hearing on the pattern by the filing of a motions party. My respectful quick answer is that indeed the law even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court retaining an application for application ex parte. But if indeed it was the case that whenever a motion ex parte is brought, there is a denial of the right to a hearing, then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission is totally incongruous, totally offensive to the long or the age-old practice in this honorable court. Respectfully, I will respond to the contention made by my learned friend that there was an understanding of the CJ with the Speaker of Parliament and all that. I will not seek to even go into the merits of the understanding. But the point must be made constitutionally.
No, hold on, please.
Right.
I think that for the benefit of the public
right.
of this nation,
Right.
it is important to address the facts behind that matter.
Right.
SBB did, because there had been a circular in 2021 to regulate service for members of Parliament. And indeed, the Speaker of Parliament invited me as Chief Justice to discuss the return to that regulation. So I reviewed what my predecessor did, and I issued a circular. If anything, I think your submissions may address the import, the legal import, and nothing more.
Right. Lady, in addressing the legal import of that circular, I would note respectfully that I'm just looking for a circular that what is paramount before the court in an action of this nature is the proper interpretation of the Constitution. And indeed, as held in before an Atejera, even if, assuming we had written, even if the CJ had written such a letter, for me, with all respect, it's immaterial.
A circular.
The circular, written such a circular, it is immaterial for me. It is a construction of the words of the Constitution that matter. Before Atejera even indicated that this Chief Justice, who had lent himself to the process, which was subsequently pronounced upon as unconstitutional by the court, could not have waived any right whatsoever, because there's no such thing as extra law under the Constitution.